Hey guys, today we get a update on Ethan Klein versus probably the most interesting of the defendants, which would be Denims. So out of the three defendants, Denims, Casey Tron, and Frogan is going to be way later on. So she will be delayed by up to 90 days almost from where the other two are starting. Denims is probably the most interesting because there should be a clear case example of copyright infringement here. Her defenses are also quite strange, but again, maybe you just throw everything against the wall. So we get a update today, September 26, 2025. That will be the order setting scheduling conference at 1 p.m. What this means is it's kind of like a logistic thing. When does discovery happen? What can be discovered? Expert witness testimony. When do you have to present things to the court? And such as that. It basically means they're going to trial, that there is no settlement up to this point, and now this is the rules of engagement to go to trial. This case has been assigned to United States District Judge Wesley Hughes. This matters is set for a scheduling conference on the above date in courtroom 9B. Service of the pleadings. If plaintiff has not already been served the operative complaint on all defendants, plaintiff should do so promptly and shall file proof of service of summons and complaint within 3 days thereafter. So that's relevant because one of the quote defendants here is the mods of H3 Snark. We're going to see how this actually plays out. Order applies to pro se litigants. Counsel as used in this order includes parties who have elected to appear without counsel and are representing themselves in litigation. Pro se litigants must comply with this order. Notice to be provided by counsel, plaintiff's counsel, or if plaintiff is a pro se litigant, defendant's counsel shall provide this order to all known parties who have not yet appeared or who appear after the date of this order. Again, you have the H3 Snark Mards who have not been identified yet. They are a party to, they are a defendant in this lawsuit. Compliance with Federal Rules of Civil Procedure 26, the scheduled conference will be held pursuant to Federal Rules of Civil Procedure Rule 16B. The parties are reminded of their obligations to make initial disclosures without awaiting a discovery request. So this is the good faith, right? You cannot withhold things that are really important because maybe the plaintiff or defendant doesn't know how to ask. The parties are reminded of their obligations. Confer on discovery plan at least 21 days before the scheduling conference. The court encourages counsel to agree to begin to conduct discovery actively before the scheduling conference. At the very least, the parties shall comply fully with the letter and spirit and thereby obtain and produce most of what would be produced in the early stages of discovery. So even without being asked to, please work together to kind of find out what the facts of the case are. So by the time the judge reviews the case, there's no disagreement. So this is true for any court, but in civil court, criminal court, you want as a judge, you don't want to make decisions. You want both parties, plaintiff and defendant, to agree. The more they can agree, the less decisions you can make. The less decisions you can make, the less your eventual decision can be overturned on appeal. No judge wants their verdict to be overturned on appeal because, again, that makes them look bad, right? It's like, oh, you did something wrong. So the more that the plaintiff and defendant cooperate and figure out discovery, figure out patterns, fact pattern, what's the facts of the situation, the happier the judge is going to be. Parties must prepare and file a joint Rule 26 report. So this is very typical. A mandatory chambers copy of this joint Rule 26F report must be delivered to Judge Hu's box outside of clerk's office on the 4th floor of the First Street Court. The report shall specify the date of mandatory scheduling conference on the caption page under the title. It shall list the dates of the original complaint, removal if removed, a responsive pleading, and trial proposed. So yeah, you even have to propose a trial date and that is very important here. Again, it can always be moved back. Typically, it's not moved forward, but it can move. It can be moved. They just want to have some type of outline as to how this case is going to go. Statement of the case. Main claims, counterclaims, affirmative defenses, and procedural history. Subject matter jurisdiction, a statement of the specific basis of federal jurisdiction, including supplemental jurisdiction. For federal question jurisdiction, cite the federal law under which the claim arises. For diversity jurisdiction, state each party's citizenship and the amount in controversy. Legal issues, a brief description of all key legal issues, including any significant procedural, substantive, or evidentiary motion. So again, the more they can agree on what the case is about, the easier the job for the judge. So the judge is wanting them to encourage to collaborate at this point in time and figure out what this lawsuit is actually about. Damages, the realistic range of provable damages. Insurance, whether insurance coverage exists, the extent of coverage, and whether there is or will be a reservation of rights. Motions, procedural motions, statement of the likelihood of motions seeking to add other parties to claim. So again, how big could this case get? Would Frogan later join on this? It's interesting. Frogan and Denims are in the same exact court. They both live in Los Angeles. So the same court jurisdiction applies to both of them, but they've chosen two different attorneys. And you could even make the argument that Denims' alleged copyright infringement is more severe than Frogan's. You could also make the argument that Denims' lawyers are much more seasoned and more expensive and better at litigation than Frogan's. So it's an interesting dilemma, right? Do you go on it your own, or do you try to save some money and go together like Casey Tron and Denims are trying to do? Because it is going to be very expensive and it does not look like, and Ethan Klein has been on record saying that he doesn't want to settle. If he doesn't want to settle, then you're talking about, as we are going to see, we're talking about a case that could go on for 3 years. That's the current number. So we're going to go over the number of weeks. Again, it's flexible. Some things will be faster. Some things will be slower. You look at the Logan Paul versus CoffeeZilla defamation case. That case has gone incredibly slow in discovery because one of the parties, i.e. Logan Paul, is continuously trying to get information that may not even exist, right? So it's kind of like getting water from a rock. Is this really a reality? But again, the court can give them leeway to do so. So this case will probably take longer than the expected timeline that they're going to come up with. Because there's always delays, there's always lawyers being busy with other cases and so on. The discovery cutoff, a proposed discovery, and here's the very expensive part. Like, people don't understand how expensive expert discovery is. Expert witnesses are incredibly expensive. So expert witnesses typically are actually court approved. I use the word approved, but I mean like they've been in court before. So they can charge a very, very high rate. In fact, the expert witness often can charge a rate higher than your current attorney, depending on if it's like forensics or something like accounting forensics. For one of my clients, he had to hire this accounting CPA forensics guy. He was charging like $2,000 an hour. And that's actually cheap. I mean, the other people we found was $2,500 an hour. So that it can get very expensive very, very fast. Going through the document, because there is a lot to go through right now. If a notice to parties of court-directed ADR program, so that's mediation, whether or not they do mediation, the court is going to suggest it because they want this resolved without, again, the judge does not want to make a decision that can be appealed. That's the whole idea of why they need to cooperate the way they need to cooperate. Trial estimate provides a realistic estimate in days of the court time required for trial and whether trial will be by jury or by court. Each side should specify by number, not by name, how many witnesses it contemplates calling. The parties are strongly encouraged to consider consenting to trial before a magistrate judge. One benefit of giving such consent is that the parties almost always will be able to proceed to trial sooner than on a district court judge's calendar. Additionally, the parties are free to select from among all magistrate judges available for this purpose, not just the magistrate judge assigned to this case. The magistrate judges have experience and expertise in a variety of areas. So maybe they find one that knows copyright more. Only one attorney for a party may be designated as a lead trial counsel unless otherwise permitted by the court. If a second lead trial counsel is permitted by the court, both counsel must attend the pre-trial conference. Independent expert or master state whether this is a case in which the court should be considered appointing a master pursuant to Federal Rules of Civil Procedure 53 or an independent scientific expert. Again, experts being probably one of the most expensive things that you can hire per hour. Other issues, a statement of any other issue affecting case management, including unusually complex technical issues. So this might be YouTube. We know that YouTube is sometimes courts struggle to understand YouTube and Twitch and live streaming. It would be interesting to see what expert they kind of bring here, right? Parties must prepare and file schedule of pre-trial and trial dates worksheet. And then we're going to get to the worksheet. It actually breaks down the timeline. Complete the text fillable schedule of pre-trial and trial dates worksheet. See below, which is available at the bottom of Judge Hu's webpage. In addition to filing the schedule of pre-trial and trial dates worksheet along with the joint rule, counsel must email the text fillable worksheet to chambers. The court will then issue an order setting the schedule governing the case. Therefore, the parties must make every effort to agree on all pre-trial and trial dates. So here is the list, and you can see the weeks before FPTC. You can see probably going to go jury trial, which is itself a very interesting selection. I think it's interesting because a jury trial, which is what Denims wants, is more likely to not understand copyright law than a judge trial. A judge trial, a judge in copyright will know what copyright is and understand it, statutes and whatnot. So here you can see all the stuff that has to happen, and this is why cases can take years. You got court mediation panel, private mediation, joint exhibit, oppositions to motions in line, joint proposed final pretrial conference, joint agreed proposed jury instructions, disputed proposed jury instructions, joint proposed verdict forms, joint proposed statement of the case, proposed additional voir dire questions, and now you have the an evidentiary objections to declarations of direct testimony, and that's all in 2 weeks. Once issued, these schedules may be modified for good cause and with the judge's consent. The numbers below represent the court's recommended timeline. The parties may propose alternative dates based on the needs of each individual case. You're looking at, let me run you some numbers, 18, 16, 14. These are weeks. 18, 16, 14, 14, 12, 8, 12, 8, 5, 4, 2. And that's assuming everything is running on time. So it's not an easy case, especially given how many defenses Denims is trying to prove. There's, affirmative defenses is like truth. It's like, hey, yes, I did commit copyright infringement, but you have dirty hands, unclean hands. So it's not, number one, they have to prove, even the client has to prove copyright infringement. Number two, the defenses have to be rejected, right? In terms of, okay, I did copyright infringe, but I did so for a good reason, or I did so in mitigation of. This will be a very between Denims and Caseytron, it's unclear which one will resolve first, but it's definitely going to be interesting to see how two different judges handle what is very likely a very similar case in terms of copyright, in terms of fact finding. And then it would be very interesting to see the age-free snark element, which we still don't know who these individuals are. They're still active. At least one of them, I call him 9mods, is still active. And yeah, I do think in terms of the longevity of this case, if it does go to trial, it will be a very, very long case. It will be many, many years to get to resolution just because of the nature of the case and the nature of all the defenses that Denims has wanted to put out there. Anyway, let me know what you guys think in the comments below. Bye, guys.